You've asked me what procedural defenses you as a tenant may have to this eviction by the landlord. In an eviction case, a landlord is required to strictly comply with the requirements of the lease in Texas law in terminating a lease and evicting a tenant. So one of the things as a tenant that you always want to do is look very carefully at the lease and the notices you've received to determine whether the landlord has complied with the notice requirements of the lease. First thing that you have to be aware of with respect to a notice issue is that Texas law specifically requires that the landlord give a notice to vacate of at least 3 days, unless the lease allows for a shorter time, before the landlord actually files suit in Justice of the Peace Court. So if the first papers you receive from the landlord are papers from the constable and you did not receive a notice to vacate, then when you go to court, you want to tell the judge that you never received a notice to vacate. And if the judge finds that the landlord failed to give you a notice to vacate, then the judge has no choice but to dismiss the case because the landlord failed to comply with one of the prerequisites of filing an eviction lawsuit. If you did receive a notice to vacate, and you want to check to see whether the landlord gave you the proper notice to vacate, oftentimes the landlord will give perhaps a 3-day notice to vacate, which may be required under the lease, and then on the 3rd day also file the eviction lawsuit. That's called a premature filing of an eviction lawsuit. The landlord can file the eviction lawsuit in court only after the expiration of the time given in the notice to vacate. So regardless of whether you receive a 1-day notice to vacate or a 3-day notice to vacate, if the landlord then files suit before the expiration of the time to vacate, that's a defense to the eviction lawsuit because it was prematurely filed, and you would want to tell the judge that the lawsuit was filed before the time to vacate had expired. Now, how do you find out when the landlord filed the eviction lawsuit? You can find that out by looking at the eviction citation that the constable will deliver to you, because it will state on the citation the date that the landlord actually filed the eviction lawsuit. Another procedural defense that's available to the tenant in an eviction is a faulty notice to vacate. The notice to vacate is supposed to be unequivocal except in one limited circumstance, which I'll discuss in a minute. But if the notice to vacate is unclear, does not clearly demand that the tenant vacate within a certain time frame, or it demands that the tenant pay rent or vacate, then you as the tenant may have a defense to the entire eviction lawsuit on the grounds that the landlord did not give a proper notice to vacate, even if it was properly delivered to you, and even if the landlord waited the proper time to file the eviction lawsuit. The notice to vacate is supposed to be unequivocal. That is, it's supposed to demand that you vacate by a date certain. Now, there's one exception. Under Texas law, if a landlord, before giving a notice to vacate, gives the tenant a demand or a reminder to pay delinquent rent, and the tenant doesn't pay it, then Texas law says that the notice to vacate can be a pay rent or vacate notice. But it's only in that circumstance that a landlord can use a pay rent or vacate notice, and that is in a circumstance where the landlord has, prior to giving the notice to vacate or pay rent, previously given the tenant a notice to, or a reminder to pay the rent for that month. So in any case, you want to carefully scrutinize the notice to vacate and see whether it is unequivocal and clearly demands that you as the tenant vacate by a certain day. That's a common mistake on the part of landlords, and because they are required to strictly comply with the notice requirements, that would be a defense to the eviction. Another defense procedurally with respect to the notice to vacate is with respect to the method of delivery of the notice to vacate. The notice to vacate has to be either mailed to the tenant, hand-delivered to the tenant, or attached to the back of the front entry door, except in one very limited circumstance which we'll discuss in a second. If a landlord attaches the notice to the front of the dwelling unit, and by that I mean the front door of the dwelling unit and not the back of the front door, the landlord has not properly delivered the notice. The statute specifically states that the landlord, if he chooses to deliver it by attaching it to the door, has to attach it to the back of the front entry door. Now, the one exception under Texas law with respect to this is when the tenant has no mailbox on the premises and has either a vicious dog on the premises and a keyless deadbolt that prevents the landlord from entering the premises. In that limited circumstance where there's no mailbox and there's a keyless bolting device and a vicious pet or a vicious pet that keeps the landlord from actually opening the front door and attaching the notice to the back of the front entry door, the landlord can then, in that case, simply attach it to the front of the door, but it's a very limited circumstance. Otherwise, the landlord has to attach it to the back of the front entry door or mail it to the tenant by first class or regular or certified mail, or hand deliver it, that is, hand it personally to the tenant. Yet another procedural defense is delivery by the landlord of the notice to vacate to someone under 16 years of age. The notice has to be given to someone at the premises over 16 years of age. It's not sufficient for the landlord to deliver it, for example, and give it to a 12-year-old youngster at the premises. The tenant may end up with a notice, but that's insufficient delivery of the notice under the statute.
All right.
Another common notice problem is for the landlord to actually give the notice to vacate prior to the date that the tenant has to actually pay the rent. For example, if the rent is due on the 1st of the month, but the lease gives a grace period until the 3rd of the month, for a landlord cannot then give a notice to vacate on the 2nd of the month because the tenant has until the 3rd of the month to actually pay the rent. So in any particular case, you want to check the lease to determine whether the landlord prematurely gave the notice to vacate to you prior to filing the eviction lawsuit. If the landlord gives the notice to vacate before the deadline to pay the rent, then you have a defense to the eviction lawsuit because the landlord gave the notice to vacate before there was any kind of lease violation on your part. I'd like to talk about one final procedural defense to eviction, which is also a substantive defense in the eyes of some courts, and that is the failure of a landlord to give a tenant an opportunity to cure. Texas common law is clear that if a lease does not waive the right to be given an opportunity to cure a lease violation, then before a landlord can declare a forfeiture of the lease and seek to evict a tenant, the landlord has to give the tenant an opportunity to cure, that is, make a demand for performance. Now, many leases in Texas waive this right to demand performance or this right to have an opportunity to cure. But many leases do not waive the opportunity to cure. And if your lease is silent and it doesn't provide that you've waived any opportunity to cure a lease violation before the landlord can proceed with giving a notice to vacate, the landlord has to give you an opportunity to cure. So, for example, if you haven't timely paid rent and the landlord simply gives a notice to vacate and doesn't first send you a reminder notice that the rent is due, and the lease is silent on on the opportunity to cure. In that case, you could tell the judge, as a defense, that the landlord did not give you an opportunity to cure before giving a notice to vacate. And that would be a defense to the eviction because the landlord failed to give an opportunity to cure. The lease is silent on that issue, and Texas common law says that when the lease is silent, tenants should be given an opportunity to cure before the landlord proceeds to declare a forfeiture of the lease and evict the tenant.